Good morning, everyone. This is Marek Sobolewski from Trademark Realty. Today, actually, I have a very good friend of mine. He's one of the best state attorneys, than I ever seen. I know Jim, he helped a lot of my clients, customers, give advice. You can tell, from the experience, he cares about people, what he does. And one of the things which actually stands out from him, he goes to people's homes, most of the time. And also one of the things he does, he covers 5 boroughs except Staten Island.
Yes, very good.
On it.
I do have to say as a disclaimer, this is just a general discussion about various legal concepts. Obviously, if you wanted to retain my services, that would require a more formal relationship. So this does not constitute any type of legal advice, just a general discussion of various concepts that concern estate planning and estate administration. Again, I'm Jim Soressi. I'm a trust and estates attorney, one of many. Have a good background. Previously worked for the Internal Revenue Service in the estate tax division, and have been practicing law for over, hate to say this now, over 40 years.
So thank you, Jim, for actually joining me today at our discussion. And usually that topic, for me, it's usually very difficult about the death.
Yes.
Not everybody wants to talk about, especially when they're like 20, 30 years old, thinking ahead. But we're running into different situations. It's like our show is called, Expect the Unexpected. So you gotta be prepared for the stuff, what's gonna happen. You're thinking you have a long life ahead of you, but suddenly something happens, then a lot of issue comes up, on it. So it's better just to prepare it ahead of time than be sorry and going through the state litigation and other stuff on it.
Yes, I know that most people, I belong to a couple of networking groups, and I know every week I say this following thing, is that no one ever wakes up and says, that I want to do estate planning, or I want to do a will, or I need these other estate planning documents. There is usually some triggering event. Unfortunately, that's usually a death of someone or a significant illness, and that's what prompts people to act. But it's always good to have a plan in place. Whether you're 25 or 30 years old with young children, or if you're 55 or 75 with children and grandchildren, it's better to have your estate plan in place.
Jim, you spent decades in estate planning and administration, right?
Yes.
When you sit down with the regular New York City family, what are you trying to prevent them from happening, later?
Well, generally what happens is when people want to come and do estate planning, there's a couple of things. Usually it's prompted by doing what we call a last will and testament. A last will and testament is a document that controls the property that you own in your name alone. There's a common misconception that a will control everything that you own, and that's not true. Marek knows that I former professor at St. John's University and Malloy College, where I taught paralegals. I used to say this to my students all the time, and I say this to my clients now. When we do estate planning, what we want to do is we need two particular things. One is we have to know your family members, and that's going to be key. Who are your closest living family members? And the second is basically a list of your assets, how they're owned, and how much they're worth. So it's those two things are the starting point in doing any type of estate planning. So you start with the family. And the reason you have to know about the family is that the law provides that your closest living relatives have an opportunity to object to a will that you do. Or if you do not have a will, your property will pass to those closest living relatives. For example, Marek, you've heard me say this before. If you're married and have children, you would think that everything goes to your spouse, but that's not true. Half will go to your spouse approximately, and half will go to your kids, which is maybe not what you want to do. If you don't have a wife with children, your closest living relatives would be your parents. If your parents are deceased, it would be your brothers and sisters. If not your brothers and sisters, then your nieces and nephews. And if you don't have any brothers or sisters, believe it or not, you go upstream to your grandparents. And people have to remember, you have two sets of grandparents, your mom's side and your dad's side. So at your mom and dad's side, now you have aunts and uncles. It gets much, much bigger. So it's always important to ascertain the family tree. And the second part is a list of the assets. The assets are important because there are certain items, such as bank accounts, that have what they call jointly owned. If I have a jointly owned bank account with my wife, if something happens to me, that automatically passes to her. It's not controlled by my will. If I have a life insurance policy, I have a named beneficiary. Same thing, it passes to the named beneficiary. Annuities, pension plans, 401ks. So it's important when I do estate planning, I have to start with those two items, family tree and list of assets.
So automatically, if I'm, for example, married, and I die, my wife inherits?
Well,
No.
it depends on who your closest family. If you have no children, the law provides that you're married, 100% of what you have in property would pass to your wife. But it's first important to determine what's controlled by the will or by the law. So, for instance, if you and your wife have a joint ownership of real estate, joint bank accounts, and you also have insurance and annuities that are payable to her as beneficiary, that means when you pass away, you may not have to go to court to probate the will, or if you don't have a will, do what they call intestacy. That's without a will. Everything would pass to your wife because she's the joint owner of the bank account, she's the joint owner of the real estate, and she's the named beneficiary of the pension plans, life insurance, and annuities. So in that case, even though you have a will, it may not be necessary to go to court. In fact, a lot of people have their assets set up that way. You're really only concerned with the husband and the wife. However, if you want to give something to your children, you could also provide for that in your will. Well, most people want everything to go to their spouse first, then to the kids. The spouses spend the money before the kids. So it's important to have an idea of what you want to do as far as where the property goes. Because if you do not have a will, in that instance, you have a wife and children, as I mentioned under New York state law, the first $50,000 goes to your wife, half of whatever is left goes to your wife, and the other half goes to your kids, which may not be what you want to have happen. You really want everything to go to your spouse. So that's why it's important to put a plan in place.
Many times when you sit down with people, you go over their assets, basically,
Yes.
right?
Now, one other thing, too, is it's become less important over the years because of exemptions that are available for taxes. So, for instance, under 2025 law, there is an exemption of $14.9 million for federal purposes, which means that anything under $14.9 million will not produce an estate tax federally. And the New York State exemption is $7,160,000. So if you're under those amounts, you do not have a tax problem.
So what if you over? You have to pay just the difference?
Yes. Well, it's funny, two things. First off, if you're married, each of you and your spouse, assuming you're U.S. citizens, have a $14.9 million exemption. And so as a couple, you could shelter twice that, $14.9 million for you and $14.9 million for your wife. Most people are not anywhere near $30 million, so that's not an issue. Plus, under federal law is something called portability. If you actually have $15 million and your wife has $15 million, you could leave your $15 million to your wife, and you could also get to leave your exemption to her. So your 14.9 and her 14.9 would shelter a little bit under $30 million. Unfortunately, New York's exemption is 7.16, and this is something I talked to Merrick about when we were in our networking group, is New York is only 7.16 million, and there is no portability. So that means you have to do some planning to make sure you take advantage of the exemption of the first spouse to die. And what Marek is alluding to is that he's heard me say this before. If you're a little bit over $1.6 million, say you're $200,000 over, most people would say, hey, I'm $200,000 over, $200,000. Okay, I'm over the exemption. How much tax do I pay on the $200,000? Well, the problem is that New York taxes the entire amount if you're just over a little bit. So instead of paying tax on just $200,000, you say you pay tax on 7.3 or whatever it is. And that could run $600,000 to $700,000. They call that the New York State cliff. So for clients who are in that range of, say, $6.5 million to $7.5 million, you have to do some estate planning to avoid paying that. They call it the cliff tax. You want me to expand on what I talked about?
Sure.
The Santa Claus? Yeah. Attorney said, wait a minute. Let's take a look at this and say, what happens if you have let's say $7.4 million. You're $240,000 over the exemption amount. Since you're over $240,000 of the exemption amount, you could trigger a $650,000 tax if you have $7.4 million. So $600,000 off 7.4, that means your family only gets 6.8. New York State gets 600,000. That's horrible. You're not really getting the full exemption to your kids. So what attorneys came up with and said, hey, wait a minute. If we give some money to a charity, your favorite charity, your church, the Boy Scouts, the Girl Scouts, whatever you want to do. If you give $240,000 to your favorite charity, that's a deduction. That brings you down to $7.16 million, which is the exemption amount. Mm-hmm. And if you have this Santa Claus in there, $240,000 goes to your charity, $7.16 million goes to your kids, and $0 goes to New York State. So they call that the Santa Claus because you're doing good by giving it to a charity, but you're giving more money to your kids. And there's a provision in there that allows for this to occur only if it increases the amount to your kids. So if you were $8 or $9 million, it wouldn't pay to do that. If you want all the money to go to your kids, you pay the tax, you avoid that cliff. That's what they call the Santa Claus. That's a little bit more sophisticated planning.
Yeah, but I think it takes place if somebody is rich, has
Yes,
a lot
right.
of money. But a regular person, like what we're dealing with on a daily basis.
Yeah, 90% of the people won't apply to. But for the people who have, I have many clients who are in that range of $6.5 million to $7.5 million. So if you live for a long period of time and your assets grow in value, you could be in that twilight zone where you fall off the cliff and have to pay this tax. So I could put that clause in the will, and because I put the clause in the will, if you do fall in that small range where it's more advantageous for the charity to get the money, because it increases the amount to your kids, that's what we do.
Jim, what is called like a valid will?
Valid will? Basically, that's a formal legal requirement a document that must meet legal requirements. Basically, it has to be in writing. It has to be signed by the testator. The testator has to sign in the presence of two witnesses. Two witnesses also sign as witnesses. That makes it a valid document. And in that document, you could say who gets what property, who doesn't get property. People don't always think that a will says, this is where my money's going. But you could actually have, and I have one case like this, where a guy had 3 sisters, and he hated his 3 sisters. So he specifically said, I specifically direct that no property go to my sisters nor their children. He left everything to a cousin. A will is anything that disposes of your property or directs how your property is not to be disposed or appoints an executor or gives any instructions on estate administration.
So if you own, for example, 2-family home or single-family home, you married, and you don't want to leave your portion to wife, but that will control it or not will control
well,
it?
It would depend on how the house is titled.
Okay.
If the house is titled as Jim and Gina, his wife, that's something called tenants by the entirety. That means that technically Gina and I each own 100% of the house. And regardless of what our will says, when one of us dies, it automatically passes to the other 100%. It would also hold true for anything that's called joint tenants with rights of survivorship. So say, for instance, my sister Mary and I, we own a house in Astoria. We own it as joint tenants with rights of survivorship. That means if something happens to me, my half passes to her and vice versa. In those instances, the will would not control.
Do you find that very often, or?
Well, yes, it depends. Generally, you see spouses own it as husband and wife because that's most important. They want the house to go to the surviving spouse. But sometimes you see between a father and a daughter, they do joint tenants, which means it passes directly, and you avoid the probate of the will. But it really comes down to where you want the property to go.
So basically, it's a very good topic today.
As I mentioned, the first thing we do is find out the assets that the person owns. I think I mentioned we should also get the approximate values because of the tax situation. But most important is how it's owned. Is it in your name by yourself? Is it held as joint tenants with rights of survivorship or with your spouse as tenants by the entirety? Does it have a named beneficiary? Because the will only controls property that's in your name alone.
Going back to the will, so you need a written will, signatures,
And witnesses, yes.
And witnesses. Does the will expires or doesn't expire?
No, it doesn't expire unless you decide to revoke the will. And you could do that a number of ways. You could revoke the will by doing a new will, because if you ever see a will, the first paragraph of a will basically says, I revoke all prior wills. So that means it undoes everything that you've done in the past. Another way of doing it is you could also have a signature with witnesses. They're saying, I revoke my will dated January 15, 2025. Or, believe it or not, you could actually physically rip it up.
Really?
And that would revoke the will, yes.
You can rip it up and basically there is no will.
There's no will, correct.
So walk me through it. If you want to meet with somebody, for the first time, you're asking certain documents to prepare it prior to your meeting, right?
Yes, usually what I do is I ask for a list of their assets, their approximate values, and how it's owned. So like, for instance, if I were to interview you and your wife, you would list, say, you own the house that you live in as husband and wife. I'll ask you, do you have any other real estate? You could tell me that you have a piece of real estate in Brooklyn that you own with your brother, and I'll ask you, how do you own it with your brother? Do you own it as joint tenants as rights of survivorship? Or do you own half and he own half? It's what they call tenants in common.
So you're going very deep.
Yes. Well, that's one of the things that we do is that it's a fact-finding mission when I talk to the clients. In order for me to help the client, what I have to do is I have to explain to them, you set the facts up on what you actually own, how you own it, because that's going to dictate where the property goes and what's going to be controlled by the will and what's not going to be controlled by the will. So yes, it's a little bit more involved, but that's the starting point with that, the assets.
So we're talking about the will. Many times I am real estate broker and clients come in, they just inherited the property or they actually, the property didn't have a will. They think they're going to get money on it. The first in line, is I think we're going into probate right now or administration.
Well, it might be a good idea to talk about a specific example.
Okay.
So someone comes into your office and says, my mom died, and they want to sell the house. Your first question is going to be, well, who owns the house?
Yeah.
So if we determine that mom owned the house, then we say, okay, mom owned the house, mom is now dead. So that means that there has to be a mechanism for mom to transfer the house from her estate to whoever she names in her will, or absent in her will, whoever her closest relatives are. So my first question would be, is there a will? If you come up with a will and it says, I leave everything to my son Joe, Joe is the only son, they would be able to probate that will and then have the house transferred from the estate to Joe, and then Joe could sell it, or the estate itself could sell it once he's appointed as the executor. If he didn't have a will, she didn't have a will, he would still have to go to court to be appointed what they call an administrator. Since there's no will, the will doesn't say who gets it, but if he's the only son, he's the only distributee, he would get it. It gets more complicated if you have multiple siblings. So if it's Joe and two sisters, and everything goes to Joe in the will, the sisters still have not an obligation, but they have a right to object to the will. How do they know that Joe didn't hold a gun to mom's head and say, sign the will that leaves everything to me? We also have to make sure that the will is executed properly. And we have to make sure mom, when she did the will, have what they call testamentary capacity. Testamentary capacity means that she had to know what she was doing. So there's a multi-part test. Basically, the person is determined to have testamentary capacity if they know who their family members are. So she would have to know she had 3 kids, Joe and 2 other daughters. She would have to know what she owned. She had the house in Brooklyn. She had a house in Astoria. She had this bank account or whatever else. She had to know she was making a will, and she had to understand what the will said. And most important, no one, I call this the Godfather, no one held a gun to her head and said, sign the will. No restraint. That would be a validly executed will.
Another question I have, for example, somebody inherited the property, got the property, and there's many kids involved on it, and investors, they used to call those kids, and ask them maybe they can transfer portion to their name.
Yes.
And the kid maybe lived in another state, didn't know the value of it, and they were buying that portion for like $10.
Yeah.
Figuratively speaking, maybe I'm just exaggerating, but they were trying to make money on it.
It's $1 million house, and there's 5 kids, so they each would get $200,000. And somebody goes and says, "I'll give you $10,000 for your interest in your mom's estate." That's what you're talking about. Yeah, mm-hmm. That's something that's out there, but I think there's new laws that address that. Where if you actually have someone who buys that, there's some protections under the law. But what that person is trying to do is buy a $200,000 piece of interest in a property, $10,000, and then they make trouble trying to force the sale and everything else. So people have to be very concerned about selling an interest in their estate. It's usually best to have an attorney explain this to the beneficiaries, what their responsibilities are, because when the one sibling who is wants to sell it, he or she's going to receive notice about the will being probated or the administration, but there's nothing preventing that person from selling it to some stranger. There's other laws that's more of a real estate question than it is an estate question.
Sure. How long does it usually take to probate the will?
I know that depends on what county you're in.
So every county has their own rules?
Yeah, well, it's funny. We have what they call a uniform court system, but it's anything but uniform. Everybody does their little nuances to the rules. So, like, for instance, I understand that Kings County in Brooklyn takes a little bit longer. They had some issues in staffing in the past. Nassau is different. Queens is different. Manhattan is different. Bronx is different. So is Suffolk County. But generally, you could probably get letters of administration or letters testamentary, depending on whether there's a will or not. You could do that anywhere from maybe 6 to 10 weeks. That's a good general estimate. That's once the paperwork is submitted.
But it takes a while just to get a paperwork straight up, all documents.
Well, it depends. Like, for instance, I'm working on an estate now, actually in Westchester County. In Westchester County, a woman died, and she was survived by 2 sisters and a brother. Turned out that the brother had not talked to the family in 30 years. So we had to go find the brother. And then we actually found the brother. So now we're in the process. We sent him some paperwork for him to sign, because he was a guy who we didn't know if he was going to cooperate or not. We got that paperwork back, and now I'm working on the petition. Once I get the petition signed and I get the paperwork signed by the other siblings, once it gets submitted to the court, it could be anywhere from 6 to 10 weeks. Although there has been significant improvement in Queens, I understand it's now 4 to 8 weeks. During COVID, it was much longer, And prior to COVID, it was a much shorter time period. If you do estate planning correctly, you could actually title assets to make sure that even though you have a will, it may not be necessary to go probate the will. So, for instance, as I mentioned, I'll use my wife and I as an example. You know, we own our co-op apartment together as husband and wife, so if something happens, it goes directly to her, to me, and vice versa. All our bank accounts are joint, so if anything happens to either one of us, it goes to the other. If all our insurance, our 401ks, our IRAs, our pensions, all of that have named beneficiaries. So since it's named beneficiaries, again, even though we have a will, it won't be necessary to probate the will. What would be important is when the second of us pass away, that's when the will would be important to probate, because then it's no longer a spouse. And the other consideration, too, is 95% of the cases, you don't have to worry about state taxes. I mentioned the $14.9 million federal exemption and the $7.16 New York exemption. If you're over that amount, then some more sophisticated planning would be necessary.
What to do to avoid the probate, basically, on it?
Well, there's some people out there who think that probate is a bad thing. It's not as good as it used to be, but it's not as bad as people make it out to be. You could avoid probate by simply changing all your ownership interest in your assets to jointly owned or beneficiary designation. Mm-hmm. If you do that, there's nothing controlled by the will because the contracts control everything. So that's one way to avoid probate. Another thing that people do is something called a revocable trust. A revocable trust, you create a trust, and what you do is you retitle all of your assets into the trust. You retitle the real estate, the co-op shares, the bank accounts, your stock accounts, and you name the trust as the beneficiary of all of everything. If that's the case, when you pass away, everything goes into the trust, which is already in existence, mm-hmm. and the successor trustee then follows the instructions in the trust. No probate required. But there's an issue in doing this. First off, in order to do this correctly, you have to make sure you get all of the assets retitled. Unfortunately, I've had several cases where we thought we had all the assets retitled. And I'm going to give you two examples. One was this woman, Jean. She was a school teacher. She was worth about $3.2 million. And we decided to do a revocable trust. And the reason we decided to do a revocable trust was to avoid probate. But we had a good reason to avoid probate. Remember I mentioned early on, we always have to identify the closest living family members? Well, I asked Jean about her closest family members. Jean was an only child. So she was not married and no kids. So no spouse, no children. I asked her about her parents. Her parents were deceased. I asked her about siblings. She was an only child. So now we look upstream. Now we go up to grandparents. Her grandparents are long dead. So now we look at the grandparents' children, which would be her father's siblings and her mother's siblings. On her father's side, she had a brother. And the brother was dead, but he had two kids, her first cousins. So we identify that. Then we look on the mother's side. I said, tell me about your mother's side. She says, I know nothing about my mother's side. I said, what do you mean? She says, my family came from Italy 70 years ago. I know nothing about my mother's side of the family. So now, if we were to probate her will, we would have to investigate to find her family members on the mother's side. So we said, no, we're going to do the revocable trust. That way we don't have to go to probate. Therefore, we don't have to go hunt for her mother's side of the family. And we transferred everything into the trust, or so we thought. Then she dies. Out of $3.2 million, we have $3.2 million in the trust. And then all of a sudden, we get a statement from Chase Manhattan Bank. She has an IRA worth $150,000. And who's the named beneficiary, which we thought was the cousins? No, there's no beneficiary. Therefore, it's payable to the estate.
Wow.
Therefore, we have to go probate her will. We had a right to Sicily to find out the local town, to find out whether her mother had any brothers or sisters. And we found out she didn't. So here we are. We try to avoid the probate, and we had to do it anyway. And just last year, I had a similar case. I met with a client in Manhattan. She was only worth about $1.8 million. Nice sum of money. We transferred everything into a revocable trust. Then she passed away. We had all the money in the revocable trust. She had like 38 different beneficiaries, charities, friends, everything. And we're all set, ready to wrap up the trust. And all of a sudden, we get a statement that says she owns 6 different stocks in something called CompuShare. I don't know if you ever heard of CompuShare. The dividend reinvestments. It was in her name alone. So now we had to go, and we had to go through the probate process for only $60,000.
Wow.
So if it's done correctly, it works very good. So I would not necessarily recommend that it's used in every instance, but it's a tool that's available to us estate planners.
The trust, that's a different topic, you know.
Different, yeah,
It's completely, it's like another ocean.
Yes,
Then you're going to
yes.
start swimming.
Well, what I said, I'm going to pick on Italians because I'm an Italian guy.
Are you?
I'm Italian, so I call it the problem having the barbecue or cocktail party. What do I mean
What
by
do
that?
you mean? Uh-huh.
I get a call. I want to do with trust. What do you want to do with trust? Well, I was at a barbecue or a cocktail party, and my friend got a trust, and it does this, that, everything under the sun. Well, first off, when you say a trust, people hear the word trust and they think that's the answer to everything. The problem is that there's so many different types of trust that do so many different things. Unless you know what exactly you're trying to accomplish, trust is not necessarily the answer. It may be the answer, but it may not necessarily. Which trust is really what's going to be decided. So in that instance, if people say they want to trust, I have to talk them down and say, okay, what are you trying to accomplish? When I do estate planning, I want to see what your goals and objectives are. And then what I do is I develop a roadmap to help get you to that destination. The worst thing is that somebody has in their mind that they want to have this trust, and invariably, just like at any cocktail party or a barbecue, all the information is not 100%. People hear a little bit about this, a little bit about that, and it's really not 100% accurate. So it takes an attorney to unravel all of that.
Wow. You have different cases all the time.
All the time. Every case is different.
What got you into this type of field, Jim?
It's very funny.
How did you get involved?
When I graduated college, I had an accounting degree, and I wanted to go to law school. So I was always interested in tax. So while in law school, I took personal income tax courses. I took advanced personal income tax courses, corporate tax courses, advanced corporate tax courses. The only tax course I never had time to fit into my schedule was estates and trust. And that's my career.
Oh.
When I graduated from law school, I got a job working at the IRS I mentioned, and I became an estate tax attorney. And that's where my expertise lies, and that's where I've been practicing for the 40 years.
So that's why when you sit down with people, you also have a background on the accounting.
Yes.
And also estate and planning,
Yes.
Very deep.
I tell people I'm a numbers guy. When I was with the IRS, I used to audit estate tax returns.
Really?
Now I prepare estate tax returns, and I usually do well enough that we either could avoid an audit, or if there's an audit, I have no problem negotiating with what has to be done.
Yeah, you have a very big experience on it.
Yes.
Any type, basically cases, and you can unravel.
Yes, you can unravel that. Yes. The only thing I don't do is I don't do estate litigation. When there's a lawsuit involved, you need a trial attorney for that. I could do what I call background work, like I work behind the scenes. I know the tax law, but as far as the trial and stuff in litigation, I leave that to the professionals who do that as a profession, specialty.
Do you have an like a bad experience, with the cases?
Oh,
What people trying to hide? Sometimes they didn't tell you from the beginning. It takes much longer to unravel.
yeah. Well,
Get to the core.
I had one case that was really a litigation, which I had to have help brought in with me. I got a referral from somebody that someone had passed away, and his brother passed away. And what happened was it was a very, very interesting case and a long case. So the brother contacted me and said, "My brother passed away. I received this from the court." So I looked at the court paperwork, and I saw that someone had a will of the deceased brother, and she was the executor. And as an executor, you have to notify the closest living family member, which was the brother. So I went to meet with the brother, and I said, "Well, yes, was your brother ever married?" "Yes, he was married and divorced." "And did he have any children?" She said, "Yeah, he has 3 daughters." I said, "Well, if it's 3 daughters, the closest relative is not the brother, it's the 3 daughters." So I ended up representing the 3 daughters. And what unfortunately happened was this woman insinuated herself into this guy's life, got him to execute a will where he left everything to her, and she was appointed the executor. And what she did was she went to court, got appointed as the preliminary executor, and she started collecting the money. The problem was she stole all the money. She stole $275,000.
Well,
So we had to fight her. We had to bring a litigator in, and we had to defeat the will that basically she forced him to do all of this. But the daughters ended up losing over $275,000. So those things do occur out there. That's why it's always good to have an attorney do a will, supervise the execution, make sure it's done correctly, and do the proper administration. One thing, you haven't asked me this, but I'm going to give you my 2 cents on this. One thing that makes me shudder is when people want to go online and they want to do, Wills R Us or whatever software is out there. Nothing replaces the knowledge of an attorney who practices in this field. And I'm going to give you one quick example. I was associated with a firm in Great Neck, and a woman went on LegalZoom.com or whatever the site was, and she followed the instructions, and she didn't understand what she was doing. And once we had to probate the will after she was dead, when she's gone, that's the will. That's what we're stuck with. Because she didn't understand the way paragraphs interacted with each other, she had a condominium in Montauk that she wanted to leave to her son, but the way she put it in the will, she left it to her sister. So we had to try to undo that.
Can you do it? Can you?
Yeah, basically, it was possibly, it would have to be a gift from the aunt to the nephew. But my point is, don't do it yourself. I'm not very handy in the house, and thank God I'm in an apartment now where I don't have to do anything. But if you have a leak, are you going to go try to fix the leak yourself, or you have an electrical problem? You could electrocute yourself, or you could flood your house. So just like you would not try to do something on yourself as far as plumbing or electricity, you should have a qualified attorney do your estate planning.
Yeah, there's a lot of stuff online, and they're not reliable. When you sit down, because you don't know the background of the person on it.
You don't know the background.
Yeah.
Also, you're depending on yourself to have knowledge. Like, for instance, you have somebody who is worth $6.5, $7 million. First of all, they have the money to pay an attorney correctly. They're looking to save a few dollars. And I don't think the software is going to talk to you about the Santa Claus.
No, definitely not,
Right. Another good thing is I talk to clients, like, for instance, say young families with young children. I say, okay, if something happens to mom and dad, who do you want to get the money? And invariably it's the kids. How old are the kids? Kids are 12 and 14. Well, if they're under 12, under 18, they can't own property. So you have to set up a trust for them. So what's the earliest age you could get property? Age 18. So if you're worth a couple of $1 million, do you really want an 18-year-old to have a couple of $1 million at
Definitely
18 years
not.
old? No. You want to have it in trust. So you want to have someone control it until they're an older age, maybe 25. Maybe give a third at 25, a third at 30, and a third at 35. Why? First of all, 25 is much better than 18. By that time, they should be through college, graduate school, starting a career. And I like the idea of giving them what I call 3 bites at the apple. If they're 25 years old, but they're still a screw up, if you give them a third, they only lose a third.
Yeah.
They got 5 more years to grow up. By that time, maybe they're married, starting a family. And maybe by 35, they should be mature enough to handle the money. But I've had clients, actually, who didn't trust their kids. And this is a true story. My client's still alive. He's 97 years old. He's been a client for 35 years. And when I started, I set up a trust for his kids. We give it 25, 30, and 35. 10 years go by. He says, Jim, calls me up, Jim, we have to change the will. I said, why? Kids are older. We made it 30, 35, 40. 10 more years go by. Jim, we have to change. I go, what's the matter? He goes, the kids are older. I said, yeah, but they can't handle the money. No, they can't. So I think we went to 40, 45, and 50. Now he's 97. His kids are in their 60s. They finally get it out right.
Wow.
So, but the point is that you have that flexibility.
So your mind is different when you're younger. You're thinking
Yes.
about different stuff. So if you're gonna get a lot of money, at that time you're gonna blow it.
Right, yeah.
That's
He
basically
didn't
happened.
he didn't trust his kids to handle the money.
What's the difference between being an executor and an administrator?
Executor is when you follow the instructions in a will. So whatever the will says is what you do. An administrator is when there is no will. So you don't determine who gets it, because that's set by statute. So if you pass away and you have spouse and children, those are the beneficiaries. No spouse and children, then it would be your siblings. That's what the difference is.
Perfect. I think I'm going to ask you maybe one more case.
Sure.
You can elaborate, something stuck in your mind, which actually you helped,
I'm trying to think here of a good one that I did.
I know, Jim, you've done a lot of the different cases. You help a lot of different people to set it up, so they will be less stressful.
Okay, I think I got a good one. This has to do with somebody who had a family business. Okay. This gentleman had a family business, and he owned 100% of this family business. And then what he did was he had 9 children and a wife. I think it was a second wife. So what he decided to do was he wanted to give everybody an equal share. So he gave 10% to the spouse and 10% to the 9 kids. And we did probate the will, and that's fine. But it's interesting because he had a business, and actually the company is no longer in business anymore. Remember Toys R Us?
Yes, definitely.
This guy's company did the shelving for Toys R Us. So he had an exclusive contract with Toys R Us, which back in the 90s was big. So he left everything 10% to everybody. So now the question became, who's running the business? So we asked, who ran the business? The guy who died ran the business. I said, is anybody in the business? There was one son in the business, but what he did was he did the construction. He wasn't in the business itself. He just did, inventory, building shelves, things like that. He didn't run the business, nothing administrative. And believe it or not, this kid had a good mind for business. So what he ended up doing was he took his father's business during the estate administration period, and he started making better decisions. And he started expanding the business. And what he did was he built the business up over like a 3-year period. when the father died, let's say it was worth $5 million, and he did all this work, and by the time 3 years passed, it was worth $10 million. But so now you say, what's so interesting here? Well, think about it. This one son, he only has a 10% interest in the business. So now he built the business up from 5 million to 10 million. So 10% is now worth from 500,000 went to $1 million. So because he built the business up, when he wanted to buy out his siblings, he had to pay the higher amount. He worked against himself. It would have been a better deal if there was some type of buy-sell where he worked it out with his siblings, or the father could have left him the business and provided other things to him. So that's just an interesting case that we see.
Yeah, so that's why it's very important. If you have a business, you gotta set everything up.
And that's called a buy-sell agreement.
Yeah.
So in that instance, there was only one owner. But a good example would be, let's say you and I, Marek. Let's say we own the corner restaurant.
Mm-hmm.
You own half, I own half. If I drop dead, my shares of that restaurant are going to go to my wife. My wife may not know nothing about the business. Yeah. And she may come in and say, oh, yeah, we don't want to do this. We want to redecorate. We're going to change the menu. You're saying, wait, no, this is what Jim and I always did. No, we're not going to do this. So you're going to have a disconnect there. And she's going to say, Jim told me this business is worth $2 million, so I want $1 million. You say, it's not worth $1 million because Jim's not here anymore. So it's good to have what they call a buy-sell agreement. Mm-hmm. Buy-sell agreement is you and I decide, okay, it's worth $2 million. If I drop dead, you buy my shares for $1 million. If you drop dead, I buy your shares for $1 million. That solves many things, many problems. One, if I die, you pay my wife $1 million. My wife gets the full $1 million. That's the value. And you don't have to work with my wife.
Yeah, that's even worth more money.
That's why we're worth more money, right? Yeah. And usually that's done with some type of life insurance. Mm-hmm. So that's something important for a business as well.
We've seen maybe someone listening has been, one of the listeners has been maybe procrastinating, mm-hmm. getting stuff done. And what's your recommendation where they should start first, maybe contact you,
Yeah. Well, the first thing they should do, whether they contact me or any other estate planning attorney, mm-hmm. is you have to be prepared to have a discussion about mm-hmm. the assets that you own, mm-hmm. their approximate values, and who owns what and how is it owned. So, for instance, we said spouses could own property together. Mm-hmm. Parents could own property jointly with their kids. You need all that disclosure plus the values. And then you determine what they want to accomplish as far as where the property goes. Like, for instance, you may have several houses. You may want to leave one particular house to a particular daughter. You may want to leave your business to one of your sons. That's all the details. That's the place to get started.
Yeah, that's a very good beginning,
Yes.
Starting point. And where can people learn more about you on it? You have a website, you have the...
I have a website. It's soressilaw.com. You'll see some pictures of me on there, a couple of articles, my background. And as Marek said, I work in the 4 boroughs other than Staten Island, plus Nassau, Suffolk, and Westchester.
Why did you give up Staten Island? I always want to know.
I had 2 clients there many years ago. It took me 3.5 hours to get there.
Traffic, New York City traffic.
3.5 hours to get there, and I said, I can't do this, and I just refused to go. The other boroughs, pretty much anywhere I'll go. It's not a problem at all. And as Marek mentioned, what I do is, even though I have a home office, I used to have office space in Great Neck. I have other offices that I utilize also, but I'm like the old-fashioned doctor. Yeah. I go visit people at their homes or places of the business. That makes it a lot easier for them. And believe it or not, it also helps me, because if someone comes into my office and I say, do you have a copy of the deed? They don't bring it with them. Do you have a copy of the bank statement? They don't bring it with them. So then what happens is, okay, send it to me when you get back. They forget, a week goes 2 weeks. It's not a good process. If I'm sitting at the kitchen table and I say, do you have the deed? Well, I have to look for it. Well, go look for it in the other room. They find it. I get it right there. Much easier to do.
I really would like to thank Jim actually for joining us today. Probably we learned more than we expected on it, but always you can find Jim and the number below. You can give him a call. He's going to set up the meeting, but
Yes.
it's very beneficial. You know, you got to start planning before, then later on, maybe too late on it.
Yeah. Usually the process that I use, Marek, is this. You contact me. I get a referral from somebody such as you.
Yeah.
I'll set up an initial telephone conference, maybe run 20 minutes or so, provide a overview of the different estate planning documents. That's also on my website. I have a brochure there.
So you actually prep the person, you know?
Yeah. So what I do is I give them like a 20,000-foot overview of the different documents and the process.
Yeah, we call that POCA, preview of upcoming attractions.
Right. And then what we do is we set up a more detailed conference call where we go over the assets and the family decisions and whatever. And then at that point, I'd be able to quote a fee. Once I quote a fee, I take half up front, half when we complete the paperwork, and then we sign everything up.
Okay. Jim,
Thank you for having me.
to come in today.
Okay.
I appreciate that.
My pleasure.
Thanks,
Bye-bye.
Jim.
Thanks,
Bye-bye.
man. Bye.